Now,
we were talking about Judge Slaughter's question about weren't there witnesses who said that Chief Ratliff was there early on?
The early on, I would absolutely dispute. One of the witnesses said the chief arrived right after, I think he said just back of Amy Shannon, but he didn't give a time frame, whether that meant seconds, minutes, or whatever. Another witness said that he wasn't there at the beginning, but when he was there, he kind of stood in the back watching. Now, that is consistent with the statement that he gave to Investigator Schumacher and Ranger Cantu, because he doesn't get into the video, doesn't actually do anything until you see the light is on Mr. Nutt, and Officer Harden says to him, "Dude, she's fixing to tase you." And at that point, Chief Ratliff enters, goes into the trailer, take Mr. Nutt out. Also evident from that, you can see that this is a travel trailer. This is not a mobile home with a porch in front. He's standing right in the threshold of his door. There's a set of steps, and it is realistic to presume that had A. Shannon hit him with the taser and he fell down the 2 or 3 steps from there, he would have been severely injured.
Why would they need to hit him with the taser for public intoxication?
They don't. And that's why Chief Ratliff stepped in.
Well, counsel, he's the chief. Why didn't he could have just ordered Amy Shannon to put down her taser?
That's not in evidence. We don't know the relationship with these people as far as do they immediately obey, do they not? This is a small town. The chief took the action, which according to him was what he saw. He didn't want this fella to be hurt. And all the other, what I would say is there's innuendo. Well, he could have done this and he could have done that. He did this. He stepped in, stopped Amy Shannon from affecting her taser, and took Mr. Nutt out.
But it's not like he was rescuing him. He actually cuffed him at the same time, right?
I'm sorry, I couldn't hear you, sir.
It's not like he was rescuing him from being tased. He actually cuffed him at the same time.
No, he did not. If you watch the video, the chief takes him out and turns him over to the other officers. They cuff him. In fact, at one point, Mr. Nutt says, "Can I have these in front?" or something like that. And one of the officers says, "No, you blew that by not coming out when we told you to." But the chief did not arrest him as far as putting him in the cuffs. It had nothing to do with that. His only involvement was to go into the trailer and take Mr. Nutt off and turn him over to the other officers. The other thing is, immediately after this question, where the investigators asked him why did he go into the trailer, they asked him was whether he considered this an illegal arrest. And he says, yes, I feel it was an illegal arrest. I mean, he had no right to run back in the trailer. Now,
counsel, just to clarify, you're saying a legal arrest or an illegal arrest?
Legal.
Okay, thank you.
The question asked to him was, so at the time you go out there, your understanding is that you consider they had a legal arrest or what? That's what my understanding was, and I still feel it was a legal arrest. I mean, he had no right to run back into the trailer.
Counsel, I mean, the whole basis of this case is that Mr. Nutt was publicly intoxicated, but if he goes back in his trailer, he's no longer publicly intoxicated, so he's not in public. So is your contention then that Mr. Nutt should have stayed outside and continued to commit a crime as opposed to going inside and stopping committing a crime? Like that's where I'm struggling with where
well, Judge McClure, first of all, introduced in the evidence is or discussed is the Santana case, I believe, your Supreme Court case. And in that case, what they stated was standing in the threshold of his door, he's still in public. So even in the door, he is publicly intoxicated. But
so he shouldn't have answered the door, right?
Sir?
So then he shouldn't have answered the door.
Yes.
Okay.
There are our case law is replete with people being arrested at their own house, on their front porch, et cetera, in public. But what I'd like to point out is that Chief Ratliff's comment they didn't have the right to run back in his trailer. That's resisting arrest. Now, ultimately, all Mr. Nutt was charged with was public intoxication. It doesn't mean he could not have been charged with other offenses. And it doesn't mean that Chief Ratliff knew that's what he would be arrested for at that moment when he turned him over to the officers. Had they charged him with resisting arrest, they deal with that also.
So the chief was there as basically additional backup and support for the main officers.
It's my understanding, Judge Slaughter, that the entire police force was there. It's a small town. And it's my understanding that every one of them was arrested had cause to be arrested by the district attorney in January of 18. And they all were replaced with a completely new police force.
Am I wrong? Am I wrong that this case, though, is about tampering with a government document?
Yes, thank you, Judge. And let me address that. The State's Exhibit 1 is the offense report. And what they accuse Chief Ratliff of is not including in that report the facts of the arrest. Now, number one, on page 2 of the report, there is a box check that says, and I cannot see the timer, so I presume I'm in my last minute.
You have 2 minutes.
It's very small. But in the report, it's checked that there is video evidence, and the video was actually turned over to the municipal court prosecutor. The state wants to say that the video is not part of the police report, and we would suggest to the court that by checking that box, that in essence incorporates the video into the police report, and the prosecutor would expect to see it. So, but more importantly, there is no requirement to include the facts of the arrest as opposed to the facts of the offense in the police report. Personally, I have seen thousands of offense report, and other than resisting arrest, I don't recall seeing many that went into how the arrest was affected or whatever. The offense report should and does in this case convey the facts of the arrest for public intoxication.
And it wasn't the chief's offense report, was it? It was the officer's offense report, and he just signed off as supervisor. Is that correct?
Yes, that is correct. That's
Counsel, is there
absolutely
anything in the record or that would explain what it means when a supervising officer signs off on an arrest report? Because I assume that he's not always on the premises where the arrest occurs. What does it mean? Do you know? Or does record show?
You know, that to the extent the state wants to say that he's responsible for what's in the report because he has approved it, I'm not sure anybody could disagree with that. The heart of this case is not did he sign off on it, was he responsible, but is there any omission, or did they intentionally leave out some facts that should have been in there? And the answer is no. What I would like to do.
But this is also about official oppression. It's not just did he leave facts out of a police report. Correct?
But there are two convictions, and the sufficiency of both is before the court.
Right.
And if I might,
Counselor,
I'm sorry.
go ahead. Go ahead.
I would like to propose a situation and ask you to propound it to opposing counsel. The scenario here gives rise to the fact that in every Franks case where there is an omission, that the officer could be indicted for tampering with a government record and could be prosecuted for official oppression if the actions following the search warrant led to someone's arrest. And I'd ask you to ask Mr. McAfee whether he intends to prosecute officers in Franks situations for tampering and for official oppression. I'll reserve the rest of my time.
Thank you, counsel.
May it please the court, counsel. I'm Wiley McAfee, also known as Sonny McAfee, and referred to in the record as Sonny McAfee. I was the lawyer that tried the case. I'm actually going to start with part of counsel's last question, if I may, about Frank's issues and whether or not we would prosecute. Having been an officer for over 20 years with the Houston Police Department, retiring as a homicide lieutenant, I'm very sensitive to issues such as Frank's or motions to suppress or constitutional violations that could be prosecuted as official oppression than those that are not? And the answer is only when officers know their conduct is unlawful and they engage in it anyway, is it fodder for official oppression. And this is one of those cases. They knew the conduct was unlawful, especially appellant knew the conduct was unlawful, and the tampering with the governmental record. The things that are left out of the governmental record, the report, are quite significant. The fact that counsel says, well, they checked off a box. Well, they checked off a box that says a playground and a park as well, but it certainly wasn't. It was in somebody's trailer. So the boxes that are checked doesn't incorporate everything in by reference into it. What they left out in this particular case, and I say they because when that chief signed off on the report, when he initialed that report, as Lisa Boynock, 38-year veteran with Houston Police Department, talked about, and the FBI Academy, that is approval of that report and the facts that are contained in it. And in this particular case, the chief was there. The appellant was there, so he knew that those facts were false by leaving out the fact that they had the interaction with Hardin and Amy outside that trailer for 10 minutes.
Counsel?
Yes, ma'am.
I guess
Yes,
I'm just troubled by, you talk about the fact that the chief signs off on a report and the distinction of whether he was there or not. I imagine that it's common practice for a supervisor to sign off on all reports, regardless of whether they were there, because they can't be there for everything. They're just kind of signing off on their subordinates' reports. And so how can they be held liable for acts of omission or false statements within a report if they don't know that they're false?
Oh, they can't, Judge Slaughter. If they don't know that they're false, then they're not tampering with the governmental record. As we alleged in the indictment, and as this statute requires, they have to be aware of the falsity of that statement. So just because they sign off on something, if we can't prove that they knew it was false, then they can't be prosecuted for it. Did I answer your question?
What is it that you believe was false within the record that the appellant knew was false?
I'm sorry, within the record,
within the police
record?
report, within the police report, what within the police report do you contend was false that the appellant was proven to have known was false?
Okay, one, that there was the interaction with Amy Shannon and Grant Hardin in trying to coax the defendant out of the trailer, the RV, so that they could arrest him in public for 10 minutes. That interaction is very significant, along with the threats that they made to try to get him out. Two, and the most important part, is the entry, the unlawful entry into the residence of Corey Nutt. And three, which is also very significant, is leaving out the witnesses that actually knew what went on that could contradict what was contained in the report or left out of the report. As much as the Court of Appeals, the Third Court of Appeals, I believe, got it right. And they cited the case of Bryan for indicia of guilt being a very strong evidence of knowledge, which I certainly agree with. And in the Bryan case, one of the issues was that Bryan's buddy, who was on the motorcycle with him when he hit this girl, he urged the buddy, don't let him know about this other witness. Keeping witnesses in that could actually talk about what did happen, such as Christy Schutte, is a very important part. So those are the things that are omitted from the report that I consider extremely significant, Judge.
But an act of omission is defined differently than an act. So how do you find that an omission from the police report gives rise to this offense?
Well, we didn't indict as an omission. We indicted as an act. He made, used, or presented the governmental record. The manner and means was through omissions and misrepresentations. The offense report represents that the arrest occurred outside in a public area, which it absolutely did not. That's a misrepresentation. Omissions about the witnesses or manner and means of the way that we got to the act of using. So we didn't indict him for omissions. When you look at the overall record and you know that it's false by its impression, by the way it's presented, and by the misrepresentations that are contained in there, that's a manner and means to show that it's a false governmental record or been tampered with.
Counsel, Penal Code Section 601C says a person who omits to perform an act does not commit an offense unless a law as defined by section 107, which is definitions, provides that the omission is an offense or otherwise provides that he has a duty to perform the act. I guess was there any testimony that he had a duty to include what was omitted?
No, Judge Keller, and we didn't indict it by omission. We indicted by commission. The fact that he made the record when he ratified it by initialing it, he presented it when he made it available to prosecuting attorney, the city attorney for that, and he used it as an official record of the department. We didn't indict him as an omission. And I'll refer you back to a case that was cited in the brief, the Oler case out of the Dallas Court of Appeals, where there they based it on the omissions of the defendant from not giving out information to doctors when he went and fraudulently got the prescriptions. And the court explained, no, this was an act. The possession of the drugs was the act. In this case, the use or making of the record was the act. That's a physical act. When he signs off on it, that's a physical act as defined under 107. So our position, I assert that 6.01 is an absent to the indictment and the proof that we had at trial. And again,
excuse me, counsel, what about the appellant that the video fills in some of the facts that weren't in writing for report purposes?
I'm sorry, but you cut out. Didn't hear most of the question.
I said, what about the appellant's argument that the video fills in what might have been missing from the written report?
The video doesn't fill in, Judge, the misrepresentations in that report. It's apples and oranges. We have a video and we have the governmental record, which is the report itself. It's not incorporated by reference. It's not a piece of evidence that went with the report. The report specifically leaves out an unlawful entry into the residence. That's a significant thing. By leaving that out of the report, just because the video shows it, is apples and oranges about whether there was tampering with the governmental record in this case.
Mr. McAfee,
Also, let me
go ahead, presiding judge.
ask you another question. I know that the state doesn't have to prove motive, but we know that Officer Hardin's motive would have been the argument earlier in the evening. Officer Shannon engaged in some strange behavior, but I think the record shows her mother had just died, so there's some kind of explanation. What is the state's theory about Chief Ratliff's motive for the illegal arrest?
Well, that's a very interesting question, Judge, and thank you for it. We didn't address motive in there, but the state's position in the motive was the fact that he's in the back, and the entire group of officers were not going to tolerate somebody that wouldn't do what they said. As Lotta said to Corey Nutt when he's led down the steps and asked to be handcuffed in front instead of back because he's a real big guy. No, you lost that chance when you didn't do as we said. It was part of the same mentality. He didn't come out, and as Chief Ratliff told Jack Schumacher, he had no right to go back in that trailer. It's all about the entitlement of the police in this case, which is one of those things that differentiates it between something that would be a motion to suppress as opposed to an official oppression case. That is the position of the state, and Chief Ratliff's motive was just.
Well, thank you. That raises another question, though, because you said that he said that Mr. Nutt had no right to go back in the trailer. The question in this case is not whether Mr. Nutt had a right to go back in the trailer, it's whether Chief Ratliff knew that he had no right to go back in the trailer. So the first question is there a possibility that he did have a right, that he had no right to go back in the trailer? Excuse me.
Is there a possibility? Certainly there would be a possibility, and the jury resolved those conflicts. The jury were the people that got to hear the facts and determine who was credible, who was not credible, and what the facts were.
But whether he had a right to go back in the trailer or not is a legal issue. The jury doesn't understand about that. I mean, that's it. And maybe he did, maybe he had no right to arrest him. Maybe he did have a right to arrest him. But the real issue is, how could he know that he didn't have a right to arrest him if he's saying he thought he couldn't go back in the trailer. I'm so sorry, but you agree, right? That's the issue, whether he knew that his act was illegal.
Whether Chief Ratliff, the appellant, knew his acts were illegal? Yes,
Right.
that is the issue. So I'm not sure about the question. So let me see if I
But
understand.
here, let me restate it then. So
Okay.
in order for him to know that that his action was illegal, the action would have to be definitely illegal. So are you taking the position that under no circumstances could an officer follow a supposed defendant into his home to arrest him for a misdemeanor like public intoxication?
Absolutely, that's the position I'm taking, Judge. That, and 1405 is clear. Unless there's an exigency or consent or a warrant, you don't have the right to go in there, along with a lot of case law such as Kirk versus Louisiana that have established those same things. To go in on a Class C misdemeanor would be absolutely unlawful under these facts and circumstances. Yes, Judge.
Counsel, well, didn't appellant also state that he believed that that he was able to go in and arrest for resisting arrest even?
No, Judge, appellant never said, other than the argument today that and the argument at the Court of Appeals, there was no resisting arrest. There's no one that claimed there was resisting arrest. There was no one that was arrested for resisting arrest. Resisting is not going back into the trailer. You have to use force against the officer that is arresting you. And nobody ever claimed to arrest him. There was no force used until they're outside the trailer and they're talking. And the only force was when Chief Ratliff went in, put his hand on his back and guided him out. And that was the force by the police and the threat of force by Amy Shannon. So there was no resisting arrest. And the appellant never in his interviews ever claimed anything about resisting arrest, nor did anyone else other than Amy Shannon saying that by not coming out and complying with him, he was resisting. Clearly, that's not the case. That would be a bogus charge. Did I answer your question, Judge?
Yes, thank you.
Okay. So going back to the tampering's by commission, not omission. His knowledge, one of the best indicators of his knowledge that what he did was unlawful, I think, is the incident report. Of course, we also have the training, and we distinguish in our brief the difference between Ross and Reynolds. And once again, the appellant says that that's the linchpin of our case and their cases, which clearly is not the case. That is just one component, the training. But it was pointed out that he's a chief of police and he's had training as a chief of police. He's got an advanced degree and he's had training that all officers have to have. And this is not an unusual situation of dealing with intoxicated persons or people in their residences. So his training certainly would cover those things, or at least be a component, something the jury was entitled to consider. The interaction, seeing the officer standing out for 10 minutes out in front of a trailer, not going in to get him if they thought they had a legal basis. No, I think jurors can make reasonable inferences, as was testified to by both Jack Schumacher and Lisa Boynock, that if they really thought it was lawful, they would have gone in there. And if they really thought their conduct was lawful, they would have put it in the report. There's no reason not to include those details unless they're covering their own conduct, which is.
Well, could it be that they didn't go in because somebody else was already going to do it? So in other words, we'll stand outside while the chief does whatever he's going to do.
It's a possibility. I don't know what was in the chief's mind or what was in their mind other than what they expressed, and by what they expressed, they weren't waiting on the chief to do anything. They were trying to talk him out into the public. It was pretty clear from testimony of the officers, as well as what everybody can see in the video. They knew they couldn't go in there and arrest him for public intoxication out of his own home. He wasn't intoxicated, the public, when they arrested him.
Well, when you say they knew, it's pretty
Yes.
clear that Officer Harden knew, and maybe Amy Shannon knew. We don't know about Gerald Lotta, but I think a lot of this has to do with how long Chief Ratliff was on the scene. And there was one witness who testified that he arrived right after Amy Shannon, but the other one said, okay. So Corey Nutt didn't say so. Corey Nutt said he didn't see him when he opened the door, and didn't see the chief, and didn't see anything that would have made him think he was there. But the neighbor, Britton, said he wasn't sure the exact time, but probably 10 or 15 minutes before the chief showed up. 10 or 15 minutes after the episode started. The whole episode was about 15 minutes. And then it struck me that the prosecutor was surprised by that. Oh, you were the prosecutor. Because you said now a minute ago when counsel was asking, you said there were 2, maybe 3 officers out there when you went out and heard them banging. Have you ever told anybody anything different? Do you remember telling Jack Shoemaker that I go out and find all of them? There's 4 or 5 of them city cops out there. And he doesn't remember. He just says, well, there was more than 2. I couldn't remember exactly how many. But that's kind of critical, isn't it? I mean, if Chief Ratliff didn't show up until when he showed up on the body cam, then he didn't know about all this. All he knew is what Hardin had told him.
Yes, Judge Keller, it could be critical. That's why when Christy Schutte said that, yes, she knew all of the officers. She knew them by sight because she's grown up in Llano and most of them grew up in Llano. And she said, yes, Chief Ratliff showed up right after Amy. Her testimony was critical to the state's case and apparently to the jury as well, because they resolved those issues based on the testimony they heard. And Chief Ratliff arrived for Christy Schutte just right after Amy Shannon. So the jury was free to believe which one of those accounts they wanted to believe. And looking at the evidence most favorable to the verdict, certainly there's sufficient evidence that the jury could believe that he was there the end time, saw the interaction, knew those things, and did nothing to stop one, and then unlawfully went into the trailer.
And he still could have thought that was legal, though. That's what he said. And I know the jury didn't have to believe him, but it's not so. I mean, I don't think any of us want to prevent officers from making judgment calls and doing their job and feel threatened with getting charged with criminal offenses if they don't. But where do you draw the line between an officer making a mistake and an officer deliberately doing something illegal?
That's a great question, Judge Keller, and I appreciate you asking it. You draw the line when officers get out there, they threaten somebody's job. They threaten to come in and arrest him for other charges. They threaten him with tasing him, all over being intoxicated just because he threatened one of their officers, or not threatened their officer, but had the temerity to say, slow down, there are kids out here. And then when he didn't comply with what they said, they don't have the right to go in there under the 4th Amendment and take him out. 1405 is very clear, and every officer knows dealing with drunks that you don't arrest somebody for public intoxication when they're in their house. When they break the law, knowing they're breaking the law and doing all of those things in retribution, that's an official oppression case. That's not something every officer is going to be charged with, and that's where you split the line.
Oh, I agree. But it was Officer Hardin who threatened his job, Officer Hardin who got into the argument with him, and Officer Shannon who threatened to tase him. Chief Ratliff didn't do any of that.
Chief Ratliff went in unlawfully and got him out of the trailer. And if you believe Christy Schutte, as the jury apparently did, then he was there long enough to know these things were happening. And he's not just backup for those folks. He's the chief of police. He's got the responsibility to control that scene and control his officers and find out what's going on. If he didn't know, that's what the testimony was, that it's the chief's job to find out. He didn't do any of those things. Instead, he allowed an arrest, and then they put him in jail. If he truly wanted to just stop a man from being tased, he could have told Amy Shannon to put down her taser or control the situation and let Corey Nutt go back in his trailer. But they didn't. They put him in jail overnight.
Mr. McAfee, I do have one question that started this whole fiasco. Was there any evidence to show that when Mr. Nutt screamed at the vehicle speeding by his trailer or his property, that he could have known that was a police officer in the vehicle?
There was evidence that he knew that the officer lived 2 doors down from him, but there was no evidence to show that he recognized that truck as being a police officer when he told him to slow down.
It was a private vehicle, right?
I'm sorry, a private vehicle, that's correct. He was in plain clothes in a private vehicle.
Okay.
That's correct, Judge. And I see the clock is going the other way, so I think I must be out of time. But thank you for the opportunity to be heard on this case and appreciate it. And I ask that you affirm the Third Court of Appeals. Thank you.
Thank you, counsel.
May it please the court. First thing I'd like to point out is the word omission is in the indictment. Also, what I'd suggest is the Oler case is cited by the state, and I would suggest they lose under any interpretation. One of the judge says it's an omission, one says it's a commission, but there's nothing similar to this case to bring Oler to control. Now, the other thing is, it's really important, is the arrest that was made for public intoxication. There were no witnesses to that other than Mr. Nutt and Grant Harden. According to Harden, all the facts leading to Mr. Nutt's arrest occurred between those two. There were no other witnesses. He wasn't arrested for not coming out or any of that. And as one of you pointed out, the chief didn't threaten him. Chief didn't do anything but come in and diffuse the situation. But it should be clear, the facts that led to the arrest of Mr. Nutt occurred between Grant Harden and Mr. Nutt. None of the other officers were there. So that even if, as Mr. McAfee suggests, the jury was free to believe that Kevin was there for most of the time, because it's clear there was no one there but Harden and Nutt to begin with. Well, he watched what happened at the door, which is on the video. None of them, and certainly not Chief Ratliff, saw the facts, saw the events that led to Mr. Nutt's arrest. Now,
Mr. Schulman, the video reflects that you can't dispute that the chief went in there solely for the purposes of, and maybe it was to protect him from falling on his face, but he almost immediately turned him over to be handcuffed. There's like a 7-second difference between escorting him out and turning him over to another officer who has his cuffs ready to cuff him.
yes.
I mean, that was his reason for going in, was to arrest him, right?
Was it one of the reasons? There's no evidence of that. And the only evidence is from the transcription of the interview in which he said, my reason was to go in to stop this 300-pound man from being tased. Oh, I can't tell you that he thought it through far enough to say, well, once I get him out of there, he's not going to be tased. He's going to be arrested. And, you know, maybe he should have done this or done that. Maybe he should have walked in the door and stood between Amy Shannon, et cetera. There's a lot of things he could have done, but that isn't the question. The question is, what did he do and what did he know? And from early on in their investigation, it's clear from the interview that the DA didn't get involved in this until after November of 17, when the charges against Mr. Nutt were dismissed. But it is clear that he was saying he went in to stop Mr. Nutt from being tased. Now, again, as one of you brought up, and you'll excuse me, half the time I can't see who's talking, but you know, where do you draw the line between an officer who makes a mistake and an officer who does something with the intent of something? And there is no evidence that Chief Ratliff had any intention other than to make sure Mr. Nutt wasn't tased.
Well, he
did
immediately turned him over to another officer who cuffed him almost
Yes.
within seconds of escorting him out of the mobile home. That would be something a jury could consider.
And he did say that he can't run back in. So there's an implication that he thought, well, that he
Yes.
thought that that he was thinking about whether he could arrest him or not legally, and thought that he could.
And again, Judge Keller, it's like the DA gets involved in the end of 2017, and they interviewed Chief on January 12th. And he said that he thought the arrest was legal based on Nutt having gone back in the house. But again, the arrest was for the events that occurred in the first two interactions, in the two interactions between Harden and Nutt when there were no witnesses.
Counsel, are you familiar with the case that's pending in the United States Supreme Court now, Lang versus California?
Langley?
Lang versus California.
Yes, in fact, we submitted a supplemental list of authorities early on, and of course, we were hoping it would have been resolved beforehand.
Oh, I
It
didn't see
wasn't.
that. Sorry.
But you know, there's two other things I'd like to discuss, and I'll come back to that. Number one is the question is, Mr. McAfee has posed that the fact that the other officers didn't go in and arrest Mr. Nutt demonstrates that they knew they weren't allowed to. Well, that was also brought up in the interview in January. And investigator Schumacher says, why do you think that the officer stood there on the outside the trailer and on the steps for so long without going ahead and placing him in handcuffs? And the chief says, maybe they weren't comfortable with dealing with him. I mean, he was a big guy. He's probably two of me. I've never seen Mr. Nutt. I have seen Chief Ratliff. But the point is, as I was reading that thing, I thought, who wants to mess with a 300-pound drunk? And one of the things you can take from that video is he is not fully coherent. I can't say he was intoxicated, not my call, but it's also clear he is not cooperating and he's not listening. So maybe that's why they didn't go in there. We don't know. It's certainly not because, or certainly there's no evidence. It's because they knew they couldn't. Mr. McAfee also made comment that what happened was because they wouldn't tolerate Mr. Nutt not doing what they told him. That in the vernacular is known as the attitude test. He failed the attitude test. And what I would say is wouldn't tolerate is Rodney King, where a person commits a minor infraction and then doesn't do what the police tell them, and 6 or 8 or 10, whatever's in the Rodney King video, set upon him with clubs and kicking him and stuff, that's wouldn't tolerate. Now, to the extent that you want to say Chief Ratliff wouldn't tolerate, you look at what he did. He walked in, talks to him in polite tone, says, I'm taking you out, and took him out. Now, is it perfect? No. Obviously, we're here because we can second guess all the things that he does and say he should have done this, this, and this. But the bottom line is his goal was to make sure it wasn't being tased, and his goal was to effect an arrest, which he believed, as evidenced by the recording, that he believed was legal. There is no evidence that he knew it was illegal. There's also no evidence of the training at all. They didn't put in anything like that. The last thing is I would point out that the offense report, the jury saw no other offense reports, none of his, none he had approved. If they had seen anything where they normally include the facts of the offense and they weren't here, that would justify a jury believing that it should be in there. But there is neither statute that requires it, nor local practice, nor written policy. The facts of the arrest are simply not relevant and material to the facts of the offense. In closing, I would talk about the Supreme Court case, Caniglia versus Strom, which came down on May 17th. There is language in both Justice Kavanaugh and the Chief Justice's concurring opinions that basically say, and certainly addressing this situation where Chief Justice Roberts said, when you're going into a house to prevent an injury, a warrant is not necessary. Now, whatever we want police officers to do in these confrontational situations is not injure the person. Take them into custody as quickly and as easily as possible. That is exactly what the chief did, and he should not be punished for that. He should be saluted. I ask you to reverse the Court of Appeals opinion and render a judgment of acquittal on both cases. Thank you.
Thank you, counsel. The case is submitted and the court stands in recess until 10 o'clock.